The fourth mistake is that very few documents have all the provisions to minimize the taxes. And there are several types of taxes. There are generation skipping transfer taxes, there are excise taxes, but the main three are the estate tax, income tax, and capital gains tax. Let's talk briefly about the capital gains tax. Fortunately, Arizona is one of 9 community property states. If you have your assets as husband and wife titled as community property, upon the first death, everything will get a full step up in cost basis. It will wipe out all of the capital gains tax. The fact that you live in Arizona does not make them community property. All of your property, real estate, brokerage accounts, anything that has a tax basis can get a full step up in basis if properly titled in your estate plan. We have a community property agreement that converts literally all of your assets, including retirement assets, to community property, which is a huge benefit. Without that, on the death of a first spouse, there will not be the full step up in basis for the survivor. If survivor sells assets, he or she will face capital gains tax. Of great interest, there is now a provision that upon second death, there can be a step up in basis again when it comes to your beneficiaries. So not only on the first death, but also on the second death, we can wipe out capital gains tax. The next big issue is income tax on retirement assets. If you have an IRA, a 401k, a 403b, or a 457 plan, those are pre-tax dollars. As those come out, they get taxed. Death or incapacity or other issues can affect how those are taken out and the tax that's on those. There was a Supreme Court decision, Clark versus Rainmaker, 6 years ago, that held that an inherited IRA and other retirement assets is not protected from creditors. And if your beneficiary under any retirement plan is anyone other than a spouse, that is subject to be taken by an ex-spouse, by a creditor, for medical expenses, any other thing that would jeopardize your beneficiaries. It's possible to protect those assets in a trust, but you have to have a special trust called a qualified trust with conduit trust provisions. Then the assets can be stretched out by your beneficiaries to the maximum amount and also be protected.